At 8:47 a.m. Eastern Time this morning, United States Marshals arrived at Mar-a-Lago carrying a court-authorized writ of execution, formally initiating asset seizure proceedings. 3 federal marshals were on site, accompanied by a team of licensed appraisers and supported by local law enforcement. Their mandate was to enforce more than $550 million in outstanding civil judgments. Before assuming this is extraordinary political retaliation, it's important to understand what a writ of execution actually represents. This is a routine legal mechanism issued after a civil defendant loses in court, is ordered to pay damages, exhausts all appeal options, and still fails to satisfy the judgment. When that happens, courts authorize law enforcement to seize and liquidate assets to cover the debt. That is precisely where things stand now. In February 2024, a New York judge entered a $355 million civil fraud judgment. In March 2024, a separate jury issued an $83 million defamation verdict. With interest accrued over 9 months, the combined total now stands at $512 million. That figure continues to grow by approximately $130,000 every single day. Appeals were filed, those appeals were rejected, the judgments are now final, and once a civil judgment becomes final and remains unpaid, enforcement is mandatory. That enforcement takes the form of asset seizure. Let me walk you through the timeline that led federal marshals to the property this morning. I'll be tracking this process all the way through completion. Every filing, every valuation, every sale. If you want the facts without cable news theatrics, subscribe. February 16, 2024, Judge Engeron enters judgment. $355 million in fraudulently obtained gains must be repaid, plus interest at 9% annually. March 8, 2024, a federal jury awards $83.3 million in the Carroll defamation case. Combined liability, $438 million. Appeals are filed within days, but under New York law, appealing a civil judgment requires posting a bond, typically 110% of the judgment amount. For $438 million, the bond requirement totaled roughly $480 million. April 2024, the deadline passes. Only $91 million is posted, covering the defamation judgment alone. No bond is posted for the fraud judgment. A request is made asking the court to waive the bond requirement. The court denies the request. The law is explicit: post the bond or enforcement begins immediately. June, judgment creditors file motions seeking authorization to seize assets. August 15, the court rules that without proper bonds in place, enforcement may proceed. Asset discovery is approved. September through October, creditors subpoena banks and property records. Assets are identified: Mar-a-Lago, Trump Tower, multiple golf courses, and various bank accounts. October 9, the appellate division rejects the fraud appeal. No additional state appeals remain. October 23rd, the deadline to appeal the defamation judgment expires. No Supreme Court filing is made. Both judgments are now final. With interest, the total reaches $512 million. November 1st, creditors file applications for writs of execution in Florida and New York. November 7th, a Florida court issues the writ covering Mar-a-Lago. This morning, federal marshals executed that writ 9 months after judgment. At every stage, there were opportunities to post bond, negotiate, pay, or voluntarily liquidate assets. The choice made each time was delay, and delay has a price. Over those 9 months, the debt increased by more than $41 million. Now, let's examine what the marshals are legally permitted to seize. Florida law provides a homestead exemption, protecting a primary residence from seizure to satisfy civil judgments. But the key question is whether Mar-a-Lago qualifies as a primary residence. Legally, the property is classified as a private club, not a residence. It operates as a commercial business with initiation fees exceeding $200,000, annual dues of $14,000, and frequent events, weddings, and fundraisers. In 1993, an agreement was signed with Palm Beach converting the property from a private residence into a club. That agreement limits personal occupancy to 21 days per year. Florida courts have consistently ruled that properties operating as businesses are not protected by homestead exemption, even if the owner occasionally resides there. Mar-a-Lago is a commercial club with residential space attached. Under Florida precedent, that likely eliminates homestead protection. So what can be seized? First, business assets. Furniture, fixtures, kitchen equipment, vehicles, golf carts, inventory, all subject to seizure. Second, personal property located on commercial premises. Artwork in ballrooms and dining rooms. Antique furniture in shared areas. If it's located on business property, it's eligible. Reports indicate paintings worth millions displayed throughout Mar-a-Lago. If they're in club spaces, they're assets. Third, the real property itself. Land and structures can be seized, though this requires additional proceedings and can take months or years. If the court ultimately determines homestead protections do not apply, the entire property could be sold. Here's the irony. For For years, Mar-a-Lago was claimed to be worth over $1 billion. The fraud judgment found those valuations were systematically inflated. Court-appointed monitors estimate its true value between $200 and $400 million. Independent appraisers will now determine the actual market value. The process is deliberate. Marshals catalog items room by room. Appraisers establish fair market value. Assets are sold through court-supervised auctions. Even if every item sold for $20 million, that covers less than 4% of the judgment. So where does the remaining $492 million come from? Mar-a-Lago is only one target. Asset discovery has been initiated in 4 states, identifying additional properties, accounts, and revenue streams. Trump Tower penthouse in Manhattan, claim value $200 million. Analysts estimate $180 million. Golf courses in Bedminster, Turnberry, and Doonbeg, valued around $400 million combined, all commercial, all seizable. Licensing deals generating $5 to $20 million annually. Courts can redirect those payments directly to creditors. Bank accounts across multiple institutions. Subpoenas issued to JP Chase, Deutsche Bank, Capital One. Liquid funds can be frozen and transferred. When enforcing a judgment of this size, creditors cast a wide net. Priority goes to liquidity. Bank accounts are fastest, frozen and transferred within days. Licensing revenue follows in weeks. Real estate takes longest but delivers bulk recovery. The judgment accrues $46 million per year in interest, roughly $4 million per month. $134,000 per day. Every delay increases the total owed. Legal challenges will continue, disputing appraisals, classifications, valuations, but the appeals are finished. Enforcement is no longer optional. Every fight now is about how, not whether. Let me know in the comments, do you think the full judgment gets collected, or does this stretch on for years? Now, here's what happened when marshals entered the property. At 8:47 a.m., 3 U.S. Marshals, 4 appraisers, and 2 sheriff's deputies arrived at the main gate. The lead marshal carried the court order authorizing entry and appraisal. Security initially denied access, standard protocol. The writ was presented, supervisors were contacted, the property manager called attorneys. For 90 minutes, entry was delayed while lawyers reviewed the document, checking validity, issuance, and whether any stays were in effect. By 10:15 a.m., attorneys concluded the writ was properly issued and enforceable. Florida law required access. At 10:17 a.m., the gates opened. The appraisal team began in public club areas, the ballroom, dining rooms, corridors, and common spaces. They photographed artwork, measured furniture, checked chandelier labels, and inspected antiques. One witness observed an appraiser documenting a large landscape painting in the ballroom, noting artist and era. Another reported measurements of an antique sideboard, including maker's marks. The process was clinical and procedural. Marshals provided security but did not conduct appraisals. By 1:30 p.m., all public areas had been cataloged. Private residential spaces were not entered. Those require separate authorization. The team departed around 2 p.m. after roughly 6 hours on site. Tomorrow, valuation work begins. Comparable sales, auction records, databases. Preliminary valuations will be submitted to the court next week, listing each item with estimated market value. From there, creditors can seek court approval for auctions. For someone long accustomed to wealth insulating them from consequences, having federal agents inventory personal possessions represents a forced confrontation with reality. The law doesn't negotiate. The writ was valid, entry was mandatory. Once lawyers confirmed authority, compliance was the only option. That is accountability, immediate and undeniable. Cataloging continues tomorrow at Trump Tower. Next week, New Jersey golf courses follow. The system is slow, methodical, but functioning. This case establishes 3 precedents with long-term implications. Wealth does not confer immunity from judgment enforcement. For decades, wealthy defendants delayed endlessly. Appeals, shell companies, offshore transfers until creditors settled for pennies. O.J. Simpson's civil judgment took 25 years to collect. Bernie Madoff's assets were seized down to watches and jewelry. The message is consistent: pay voluntarily or pay through seizure. Rudy Giuliani now faces $148 million in defamation judgments. Creditors are pursuing apartments, vehicles, and memorabilia. Same process, same resistance. This case shows that when creditors have resources and courts enforce timelines, even massive judgments can be pursued. Second, civil penalties can impose accountability when criminal cases fail. No prison sentence, but asset seizure, business bans, and lifetime monitoring are powerful tools. Civil cases require a lower evidentiary standard. When criminal prosecution stalls, civil enforcement can still impose consequences. Third, visible enforcement creates public accountability. Legal filings are invisible. Marshals at Mar-a-Lago are not. It transforms abstract judgments into concrete reality and reinforces the idea that the law applies regardless of wealth or political power. The determining factor isn't judgment size, it's persistence. When creditors quit, the system fails. When courts grant endless delays, it fails. When both hold firm, it works. That's what happened today. Over the next 2 weeks, 3 developments will determine what happens next. First, appraisal valuations, due by Friday, November 22nd. If totals reach only $20 to $30 million, focus shifts elsewhere. If valuations exceed $80 million, Mar-a-Lago auctions move to the front. Second, legal countermoves. Emergency motions signal fear of total loss. Item-by-item challenge suggests acceptance of seizure but disputes over value. Silence could indicate negotiation. Third, settlement talks. Asset seizure often triggers negotiations once threats become tangible. Payment plans may replace forced sales. Watch the filings. Judgments were entered, appeals failed, enforcement was required, marshals arrived with a court order, the system functioned today. Follow this through the auctions. And tell me, what matters most to you? Appraisals, legal challenges, or settlement prospects? Because while civil judgments are significant, they may pale compared to what comes next. The DOJ has opened an obstruction probe related to the seizure. I walk through the evidence in the next video. This changes everything. Click it.